Jury deliberations resume at 9:30 this morning for Trump's New York trial. A verdict could be handed down today after jurors requested to re-examine several key pieces of testimony. That includes David Pecker's testimony regarding a phone conversation with Donald Trump, Pecker's testimony about the decision not to finalize and fund the assignment of Karen McDougal's life rights, his testimony regarding a key 2015 Trump Tower meeting when he allegedly hatched a conspiracy with Trump and Michael Cohen to help get Trump elected, and Cohen's testimony regarding that same Trump Tower meeting. Neama Rahmani is a former federal prosecutor and the president of the West Coast Trial Lawyers. He joins me now. Neama, read the tea leaves for us. Why would the jury want to revisit that specific testimony?
Todd, reading the tea leaves here, this is good for the prosecution, and this is why. We know the state called David Pecker as their first witness. So when you're a prosecutor, you want to start strong and end strong. And here's the one that directly implicates Donald Trump with this catch-and-kill scheme. So the fact that the jurors are asking for this readback leads me to believe that at least some of them are convinced of Donald Trump's guilt, and they're trying to convince those remaining jurors, whether they're on the fence or they're holdouts.
Why do you think the jury wanted the jury instructions, reread to them?
Well, most states, including our federal system, allows those jury instructions to go back into the jury deliberation room with them. New York is unique in that it doesn't. And we heard Judge Juan Merchan read those instructions yesterday, and there were some very important ones. The most important of which was that we know that the business records have to be false, but they have to be in furtherance of or to cover up another crime. And Judge Juan Merchan laid out a few possibilities. We've talked about election fraud. We've talked about campaign finance violations. And we've also talked about tax fraud. So we know that there's 2 lawyers on this panel, and those lawyers are likely leading those deliberations. So they want to sort through those instructions and make sure that they hold the prosecution to their burden in this case.
Here are the possible outcomes as it stands now. Conviction on all 34 counts of felony falsification of business records, conviction on some counts, acquittal on others, acquittal on all counts, or a hung jury. If he's convicted, Neama, where does the, quote, as I'm calling it, pick any crime, don't worry about being unanimous instruction rank on your list of reversible error on appeal? Because looking at this as a former lawyer but an interested observer, it seems like almost everything this judge has done can be and should be reversed on appeal. Your thoughts?
Well, it's certainly an appellate issue, but I don't necessarily think it's reversible error, and this is why. I know the former president is unhappy, but if they were separately charged counts, then absolutely, the jury would have to be unanimous, whether it's tax fraud, election fraud, or campaign finance violations. But if you look at New York law, it just requires that the business records be false and in furtherance of another crime. So as long as the jurors unanimously agree that another crime was committed and the business records furthered or covered it up, that should be enough for New York appellate courts. But again, it does create an appellate issue. Ultimately, I don't think the former president will be remanded to custody or sentenced to prison regardless of the outcome in this case, even if he's convicted of all felony counts. So this will just be one additional issue in Trump's appellate team can turn to when they appeal a conviction, if any.
Yeah, the other one, I think, being the main one being, hey, we didn't know what we had to defend against until literally the summation, and that's not right. Before we let you go, there's an update for Diddy. A grand jury could soon be hearing from his accusers. Do you expect prosecutors to present a full history? And I'm talking every single accuser testifying in front of that grand jury to basically build the case against Diddy?
I don't think you need every accuser, Todd, but there will certainly be many, and this is why. Normally, if you're a prosecutor, and I've prosecuted many of these cases, you don't necessarily want your witnesses before the grand jury, and the reason is you're creating potential impeachment evidence that can be used against them at trial to cross-examine them. But I think this case is unique because we know that Diddy is going to litigate this case. There's no possible deal he'll be given or one that he'll accept because he's going to look at 10 or more years in federal prison. And there's the possibility that these victims go sideways at trial. They might not show up. They may renege on their stories because they're either scared or they have a financial motive not to testify against Diddy because they're paid off. So I think prosecutors want to lock in those victims, make sure they testify under oath before the grand jury, before they return that indictment. That way, the case will be bulletproof when they go to trial.
Neama Rahmani, appreciate your time and your insight. Thank you, sir. Carly.
All right, stop and watch.